Welcome to the History, Law, and Justice Podcast. I'm your host, Michael Buckner, a lawyer and amateur historian. I will explore with you legal issues affecting governance, society, and culture of the United States and other civilizations, both past and present, using history as my guide. Before we begin the episode, be sure to subscribe to our YouTube channel. Also, you're invited to share your thoughts on today's topic or anything dealing with history and the law in the comment sections below or on our social media platforms. On June 18th, 2020, U.S. President Donald Trump, in response to two major legal setbacks before the United States Supreme Court, promised to release an updated slate of conservative candidates to serve as justices should a vacancy arrive during the remainder of his current term or a second term if he is reelected in November. Conservative commentators have been especially critical of Chief Justice John Roberts' role in the current decisions, including the Roberts-authored 5-4 opinion in a case involving the Trump administration's effort to end the Obama-era Deferred Action for Child Arrivals program, otherwise known as DACA. The president's rallying call to his Republican base concerning Supreme Court justice nominations generated a question in my mind. Does Trump or any U.S. president possess the legal right to demote an incumbent Chief Justice to Associate Justice and to appoint a new Chief Justice? This episode explores the available authority the president may have to demote or replace an incumbent Chief Justice. Before we begin, however, I want to make something very clear, and that is President Trump has not announced his intention to demote or replace John Roberts as Chief Justice. Today's episode is merely an academic and theoretical exercise for those interested in how the Constitution works in this area. The position of Chief Justice of the Supreme Court lies in an ambiguous area of constitutional law. Namely, although the U.S. Constitution references the position, it does not mention how the Chief Justice is appointed. Let's see what the Constitution actually says. Article 3, Section 1 establishes the Supreme Court and declares the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. As a result, most legal commentators interpret this provision to mean that Supreme Court justices hold office as long as they choose and can only be removed from office by impeachment. Article 2, Section 2, Clause 2 provides that the President has the power to nominate judges of the Supreme Court subject to the advice and consent of the Senate. The Constitution's only reference to the Chief Justice appears in Article 1, Section 3, Clause 6, which states that the Senate has the sole power to try all impeachments and that the Chief Justice shall preside when the President is on trial. The proceedings of the Constitutional Convention offer no help, since records indicate delegates did not specifically address the manner in which the Chief Justice shall be selected. Further, the delegates elected not to include in the Constitution the exact powers of the Supreme Court or the organization of the judicial branch of government. As a result, over the course of this nation's history, the United States Congress was obligated to fill in those gaps with the passage of various judiciary acts, the first of which occurred in 1789. The first such law set forth that the High Court shall consist of a Chief Justice and 5 Associate Justices. the number of justices on the Supreme Court changed 6 times before settling at the present number of 1 Chief Justice and 8 Associate Justices with the passage of the Judiciary Act of 1869. As you can see, the Constitution or the statutory law does not provide any guidance on how the Chief Justice is to be selected, so a definitive answer to today's question cannot be made. What is clear is that the answer lies in the philosophy advanced by one of the following 3 groups. The first group constitutes the majority of legal and political scholars, and they all believe that any replacement or demotion of a Chief Justice by a president will require the consent of the U.S. Senate. The second group is much smaller and comprises of mainly legal commentators who argue that the president could name a new Chief Justice to the Supreme Court or even change a Chief Justice to one on the court already without receiving Senate approval. The third group consists of a handful of scholars who argue that the president should not have the right to appoint a person as Chief Justice and that the members of the Supreme Court itself should choose the Chief Justice from among them. Again, each of these 3 positions technically may be correct, since the Constitution is silent on the issue, and we only have historical practice as our guide. So if a president attempted to demote or remove a Chief Justice without Senate consent, ironically, it would be the very Supreme Court that will ultimately decide on whether it would be appropriate under the Constitution. You're just listening to the History, Law, and Justice podcast with your host, Michael Buckner. Thank you for your attention. If you have any questions or feedback on this episode, Michael's contact information is included in the description box. Citations to sources used to prepare this episode are also listed in the description box. Finally, don't forget to click on the link to subscribe to receive the next episode of this podcast. Remember to let history serve as your roadmap for future success.